Judge Prager set the trust document down and looked at my husband. "Mr. Alderman," he said, "your wife's grandfather appears to have anticipated this filing." Dean stopped smiling. He had known about the $28.7 million for 11 months. That was never the secret. The secret was a single handwritten line, dated 4 years before my grandfather died. My husband erased it himself on the morning he filed, behind him. My mother-in-law reached for the back of a chair and missed it. I kept my hands folded in my lap. There was a calculator in my purse, the same one I had used for 8 years at a building supply company on Webster Street. Back when I still read things before I signed them. 16 months earlier, I had stopped reading. That was the actual beginning. 16 months earlier, November, a Tuesday, a law office on Ludlow Street in Dayton with radiators that ticked. Margot Ivers was 58 and had my grandfather's file open in front of her, the way a surgeon opens a tray. She did not soften anything. I appreciated that later. At the time, it frightened me. "There are several small bequests," she said. "The principal beneficiary is Corinne." I looked up. "Me? You?" My grandfather was Hollis Brandt. He died at 84 in the front bedroom of the house on 3rd Street. And until that Tuesday, I would have described him to a stranger in 3 sentences. He wore the same brown wool coat for 7 winters and had the shoulder seam repaired twice rather than replace it. He drove a 1998 Buick LeSabre that still sat in his garage with a quarter tank in it. And he could not watch a person pay $10 for coffee without saying something about it. $10, he would say. For a cup of hot water you walked past a faucet to get to, that was the man. That was all I thought there was. Margot kept reading. Investment accounts, 2 commercial buildings, shares in a company. I had never heard him mention a family trust, established years before, with my name inside it. He had not left me money. He had left me a structure. "Why didn't he tell me?" I said. Margot turned a page before she answered. "Because he believed that knowing too early changes how people treat you." Dean leaned toward me. He had taken the afternoon off work and was still in the gray quarter zip I had bought him the Christmas before. "How much?" he said. "I don't know yet." "You must have some idea." "I really don't." He sat back. And I want to be careful here, because for 16 months afterward, I would take this moment out and look at it. And every time I looked, I saw the same thing. It was not curiosity. It was not happiness for me either. He did not reach over. He did not say my grandfather's name. It was the face he made when a supplier sent a quote. Dean was a regional sales director. I had watched him read quotes at that kitchen table for years. And there was a particular stillness he went into, a narrowing, while he worked out what a number was actually worth and which part of it he could move. He was doing that in a law office. On the afternoon, we closed the paperwork of a man who had known him for 16 years. I told myself I was tired. Grief makes you unfair to people. I thought, on the way out, he held the door for me and said, "We'll need to talk about how we handle everything. Everything." I thought he meant our life. At home. Josie was 9 and wanted facts. Was great-grandpa rich? He had an old car, I said, and 1 coat. She accepted this completely, the way children accept anything delivered without hesitation, and went to find her brother. That evening, I went down to the basement for the box of Christmas garland and opened the wrong one. Inside was my old work case from Kessler Building Supply. 8 years. Second desk from the window. Purchase orders and reconciliations. On top of it sat a Casio HR100 adding machine with the tape roll still threaded through it. I pulled the tape out an inch. The last thing I had ever added up was a return on 42 feet of copper pipe. October 2012, 6 weeks before Theo was born. I sat on the basement step and held it for a while. Then I put the lid back on. I didn't need it. I hadn't needed it in 12 years. There is a version of this story where I was a woman who did not understand money. That version is easier to tell, and it is not true. In the spring of 2019, Dean brought home a folder of refinancing papers and set them on the kitchen table with a pen laid across the top like a bookmark. I reached for the third page, because the third page is where the terms live. That is not instinct. That is 8 years of training. He put 2 fingers on the corner and slid the pen toward me. "You don't need to look at that," he said. "I already did. And I want to be honest about what happened in my body, because it matters more than anything he said. I felt relief, not suspicion, relief. Somewhere in the 11 years since I had left Kessler Building Supply, reading a document had stopped being a skill I had and become a chore. Someone was kindly taking off my hands. I signed on the line he was already pointing at. I want to say I was tricked. I wasn't. I was invited to stop, and I accepted the invitation, and I kept accepting it for 4 more years. The first Friday in December, Oakwood Schools had an in-service day, and I decided we were going to surprise him. Dean was in Chicago for 3 days of meetings. Josie had decided, with total 9-year-old conviction, that we should bring him cheesecake, because he had once said a thing about cheesecake in 2021 that she had filed away permanently. Theo wanted to see the bean and was pretending he did not want to see the bean. I bought 3 Southwest tickets for $312 and did not tell anyone. It was the most spontaneous thing I had done since my grandfather's funeral, and I remember standing in the boarding line thinking that grief had made me strange, and that being strange was probably good for me. We landed at Midway at 4. The plan was small: check in, wait, walk into the hotel restaurant at 7, watch his face. We were early. I was standing near the entrance to the restaurant with a woman in a navy blazer. She was holding a folder against her hip, the flat institutional kind, and she was not standing close to him. That is the detail I need you to hold on to, because for a full second my mind went to the obvious place, and then it came back, and what it found was worse. Theo bumped my shoulder. I put a hand up. We stopped behind a column. I heard 3 things. The woman said, "Will she push back?" Dean said, "She's never read a statement in 16 years. And then the woman said, "I'll need the last 3 years of joint accounts." He did not touch her. He did not laugh in the way a man laughs when he is doing something he shouldn't. He answered her the way he answered anyone across a table from him, and she wrote something down. I have thought about that column for a long time. If it had been an affair, there would have been a woman to be angry at. There would have been a reason that lived in the body, that people understand, that friends know what to say about. This was a professional consultation. Someone had been hired. There was a folder. He had not fallen for someone else. He had opened a file. I took my children back to Midway that night. I told them the meetings had run long and we would try again another time. And I bought them both dinner at the terminal, and Josie fell asleep on my shoulder before we pushed back from the gate. Theo did not eat. "Why didn't we go see him?" he said. He was 14. He was watching my face for the answer, not listening for it, and I had a choice about which one of us was going to carry this. "Because sometimes," I said, "you find something out before you're ready to know it." He looked at me for a while. Then he nodded and put his headphones in. And I understood that he had understood, and that I had just made him older, somewhere over Indiana, with Josie's weight against my arm. I opened the banking app on my phone. I had not looked at it in 3 years. It took me 2 attempts to remember the password. The balance was the same as I remembered. I had no idea whether that was good news. Margot Ivers did not do reassurance. I learned that in January, sitting across from her while she turned her monitor toward me. 2 requests for information came into this office regarding the Brandt Trust, she said, both from a firm called Vane and Associates. That's Dean's attorney. That's Dean's attorney. I looked at the dates and my hands went cold in a way they never had before. The first request was logged on the 14th of November. My grandfather's will was read on the 16th. He asked before, I said. Before I knew. Before anyone in that room knew. Yes. How? Margot closed the window on her screen. That's the question I can't answer yet. And I would rather not guess in front of you, because you'll carry the guess around whether or not it turns out to be true. I sat with that. It was the first time someone had declined to comfort me, and it had felt like respect. They served me on the second Monday in January, at 9:12 in the morning. I know the time because I looked at the stove clock while the process server said my name as a question. Complaint for divorce, affidavit of property and income, Montgomery County Domestic Relations. I stood in my own hallway reading the caption over and over, as if the caption were the part that mattered. Here is what I expected, an accusation. I expected him to claim I was hiding something. He didn't. The filing was careful, courteous, and almost boring. It requested an allocation of separate property to the extent that separate property had been commingled with marital assets during the course of the marriage. That was all. No drama, no adjective anywhere in it. I have thought since about how much more frightening that is. A man who accuses you is a man who is guessing. A man who cites the correct doctrine on the first page is a man who has already been advised and has listened and has decided to be patient. Dean came home that evening at his usual time, hung his coat in the usual place, and said, "Curtis can walk you through it. Most of it you won't need to understand." I did not answer him. Theo answered him. My son was standing at the bottom of the stairs in a hoodie with a math worksheet in his hand, and he said, "Why do you get to decide what she understands?" The kitchen went very quiet. "This is an adult conversation," Dean said. "You said it out loud in front of me." "Theo, upstairs." He went, but he stopped on the 3rd step, where the landing turns, where a 14-year-old can still hear everything. And he stood there long enough for both of us to know he had chosen to. Neither of us said anything else. Dean poured a glass of water and took it upstairs. That was the entire fight. 16 years, and the loudest thing in it was a boy on a staircase. That weekend, I drove to the house on 3rd Street. I told myself I was going to check the pipes. The furnace was set to 55, and the room smelled like cold paper. I stood in the doorway of his study a while without turning the light on. The brown wool coat was hanging on the back of the door, where it had hung for 7 winters and 1 November. I don't know why I put my hand in the pocket. I'd like to say I sensed something. I didn't. It was a coat, and I was a woman who missed a man. And putting your hand in a dead person's pocket is a thing you do. There was an envelope with my name on it. I had written 4 short paragraphs. I am not going to give you all of them, but there is one line I have said out loud to myself more times than I have said any other sentence in my life. People will treat you differently when they find out what I left you. That reaction is about them, not you. I sat down on the floor of that study and cried the way you cry when nobody is in the building. And then I looked at the date under his signature, April 2019. 4 years before he died, 4 years before any of this, 4 years before a folder in Chicago and a pen slid across a kitchen table. He knew. I drove home. I went straight down to the basement, and I opened the box. And this time I took the Casio out. Discovery took 4 months. That is the part nobody tells you about. There is no ambush, no envelope slid across a table. There is a schedule, and there are deadlines. And one day in May, a valuation lands in your attorney's inbox as an attachment. $28,700,000. Dean had known since March. His firm received the same figures I did, on the same day, under the same court order. There was never a moment when I held a secret he was chasing. The story people want is the one where he finds out at the end. He found out in month 2, and he was calm about it in a way that should have told me something. I did not feel rich. I have tried for a long time to find a better word, and I can't. I felt exposed, like a house with the siding pulled off. And then I read what he was actually asking for. He was not asking for $28 million. He was asking for 3.2. I sat in Margot's office while she walked me through it, line by line, and every line was true. In 2016, we bought the house on Ridgewood. $180,000 of the down payment came out of an account my grandfather had funded in my name years earlier. It went into our joint account first. It sat there 11 days. Then it went to the title company. 11 days, that is all it takes. Separate money that passes through a marital account and cannot be traced back cleanly stops being separate money. In 2019, the roof of my grandfather's commercial building on Wyoming Street failed in a March storm. $41,000 for a full replacement, paid from our joint checking, because Hollis was 80 and the contractor wanted a deposit that week. And for 26 months after that, Dean managed the building, tenant calls, snow removal contracts, the insurance renewal. He never took a dollar for it. And at the time, I thought that was love. Under Ohio law, the increase in value of separate property that results from the labor or contribution of either spouse during the marriage is not automatically separate anymore. He had not invented anything. He had remembered everything. That was the part I could not get around. Somewhere in the middle of my grief, I had been waiting for him to be a liar. Because a liar you can hate cleanly. He wasn't lying. Every number in that filing had happened in my house, with my consent, in daylight. He might win this part, Margot said. I looked up. And if I were his lawyer, she said, I would ask for exactly the same thing. So you're telling me I should pay him? I'm telling you to know where you're standing before you decide anything. I am not going to hand you a feeling and let you walk out of here on it. That's how people lose. I have thought about that sentence more than almost anything anyone said to me that year. Everyone else had spent 5 months telling me I was right. Margot Ivers charged me $400 an hour to tell me I was exposed. She was the only one being kind. I asked her the question on the way out, with my coat half on. Does he deserve any of it? She thought about it longer than I wanted her to. Some men earn a claim and are still not owed a thing, she said. The court only rules on the first half of that sentence. I went home and I did not sleep. At 10 o'clock, I sat down at the kitchen table with 3 years of joint account statements and the Casio plugged in beside me. And something happened that I was not prepared for. My hands knew where the keys were. 12 years, 2 children, a whole other life. And my right hand found the plus bar without looking. The way you find a light switch in a house you left at 19. I worked until 4 in the morning. I found the $41,000 check myself. Margot's associate found it 11 days later and called it a good catch. But somewhere around 2:30, in the September 2019 statement, I found something else. A deposit, $41,000. Incoming. 3 weeks after the roof was paid for. The originating account was one I had never seen in my life. I circled it. I didn't know what it was yet. I only knew that in 16 years of this marriage, no one had ever put money back. Here is the thing about privilege. What a man says to his lawyer is sealed. It is one of the oldest protections we have, and it holds absolutely. And it holds only as long as he keeps it between the two of them. Dean's mother was worried. That is where it started, and I have never once believed otherwise. Loretta Alderman is 71 and has a way of asking questions that sound like weather. She wanted to know whether her son was going to be all right. So in February, he forwarded her an email from Curtis Vane laying out the strategy, because it was easier than reassuring her a fourth time. And Loretta, who does not trust anything she cannot discuss with someone, forwarded it to her cousin. Her cousin is Deanna Voss. Deanna Voss sat with my grandfather 3 afternoons a week for the last 2 years of his life. When you hand your attorney's confidential advice to a third party, it stops being confidential, not partly, not for most purposes. The protection is gone for that document, and it does not come back. Margot subpoenaed Deanna's account. It was granted without argument. There was nothing to argue about. The settlement conference was in September. In a conference room on the 4th floor with a coffee machine nobody used and a photograph of the Great Miami River on the wall. Dean brought his mother. Curtis allowed it. Margot did not object. And afterward I asked her why. And she said, "Because I wanted her in the room." I did not understand that for another 40 minutes. Margot let them talk for a while. Curtis was good. He walked through the Ridgewood transfer and the Wyoming Street roof and the 26 months, and he was reasonable. And I could feel the number 3.2 sitting on the table like a plate. Somebody was going to slide toward me. Then Margot took one sheet of paper out of a folder and put it in front of him. Curtis Vane read it. He was taking notes with a fountain pen, and he stopped, and he did not start again. It was Dean's email to him. February the 9th. She's never read a statement in 16 years. We negotiate from a position of information. I had heard the first half of that sentence before, in a hotel lobby in Chicago, in December. I had heard a version of it at my own kitchen table in 2019, with a pen sliding toward my hand. You don't need to look at that. I already did. He had said it to me as a kindness. He had said it to his lawyer as an asset. Curtis Vane turned to his client. 3 words. "Who'd you send this to?" Dean did not answer, behind him. In the second row of chairs against the wall, neither did Loretta, and I watched a 71-year-old woman work out, in real time and in front of 5 people, what she had done. She did not gasp. She put one hand flat on her purse and looked at the carpet. That was the moment Margot had wanted her in the room for. There was more in the chain. There is always more. 3 weeks before my grandfather died, Deanna Voss saw paperwork on the desk in his study, trust documents, with letterhead. She mentioned it to Loretta the way you mention anything to family, on a Sunday. Without wait, Loretta mentioned it to her son. Her son called an attorney on the 14th of November. My grandfather's will was read on the 16th. So that was the answer to the question Margot had refused to guess at in January. Nobody hacked anything. Nobody broke into a house. A woman who was kind to my grandfather for 2 years said an ordinary sentence to her cousin, and her cousin said it to her son. And her son understood immediately what he was hearing and what it was worth. It went through 3 people. Not one of them thought they were doing something wrong. That is how most of it happens. I think, not conspiracy, just a chain of people each doing the smallest possible thing. I sat in my car in the parking garage afterward for a long time without starting it. I was not angry at Dean. That surprised me, and it is still true. I had already finished being angry at Dean somewhere over Indiana in December. What I could not get past was the arithmetic. 3 people had known. Not one of them had thought I was the person who needed to be told. In October, the woman in the navy blazer withdrew from the case. Her name was Nadia Ostrom, a certified valuation analyst out of Chicago. Curtis Vane had retained her the previous November to put a number on my husband's contribution to my grandfather's building. That was the folder against her hip. She quit because of what was missing. When the full production came through under court order, she compared it against what Dean had given her and found the statements did not match. Pages had been left out, not altered, left out. The pages that were missing were the ones showing money coming back in. An expert who signs a valuation is putting her license on it. She wrote a 2-paragraph letter withdrawing, copied Margot because the rules required it, and that was the end of her involvement. She was not on my side. I want to be precise, because it matters. She never once acted in my interest. She protected her own credential, and that was enough to end my husband's case. I asked to meet her. Margot said it was unnecessary. I said I knew. We had coffee in a hotel restaurant near the airport, which was funny in a way neither of us said. The first thing I said to her was not about the case. 10 months ago, I was standing behind a column in a hotel lobby in Chicago. I said, "Do you remember what you asked him?" She put her cup down. "I asked if you'd push back. You did. I was told you were the client's spouse and that you didn't read financial documents." She said it flatly, without apology, and I have thought since that the flatness was the apology. That's a normal thing to be told. It's usually true. It was true, I said. She looked at me for a second. Not anymore. Apparently. We talked for another 20 minutes about nothing. Her daughter plays clarinet. Josie had quit clarinet in March. When we stood up, she shook my hand, and I understood I would never see her again, and that she had given me the only thing she had, which was a straight answer to a question I had carried for 10 months. 3 days later, Margot called and asked me to come in, and there was a banker's box on her table that had not been there before. Hollis Brandt had lodged it with her firm in person in August of 2021, with instructions that it not be opened unless it was needed. Inside was a ledger. $41,000 for the Wyoming Street roof, repaid on the 12th of September, 2019, from my grandfather's personal account. 3 weeks after the storm, with the wire confirmation stapled to the page. That was my circled deposit. 2:30 in the morning. The number I could not explain, $180,000 for the Ridgewood down payment, repaid across 22 months, ending June of 2021 in amounts small enough that neither of us had ever noticed them landing. And 26 months of property management, paid at market rate, with an hour sheet in my grandfather's handwriting, tenant calls, snow contracts, the insurance renewal, every one of them logged, priced, and settled. The chain was cut. Separate money that leaves a marital account and is repaid in full, with a paper trail, is separate money again. There was nothing left to trace and nothing left to argue. $3.2 million stopped existing in that room. On a Tuesday, quietly, Margot turned pages and read dates aloud, and I listened to my grandfather win an argument he had finished having 5 years before anyone knew it had started. On top of the ledger was an index card, pay it square, don't give him a reason, dated April 2019. the same month as the letter in the coat pocket. I sat down. I said, "He knew in 2019. He knew in 2019. Then why didn't he tell me?" Margot was quiet, and then she did the only cruel thing she ever did, which was answer me honestly. "He told me you'd ask that," she said. "He said if he warned you, you would have spent 4 years watching your own husband. He said he wasn't willing to take those 4 years from you." I did not cry. I remember being surprised that I didn't. My grandfather had looked at my marriage in 2019, seen exactly what was in it, and decided the kindest available thing was to say nothing and quietly close every door. He bought me 4 more years of not knowing. I still don't know if that was a gift. The trial was in March, 16 months after a Tuesday in a law office on Ludlow Street. There is a coffee stand in the lobby of the Montgomery County Courthouse. I was standing 8 feet behind my husband when he ordered a $9 latte and told his paralegal to put it under case expenses. I thought about a man in a brown wool coat saying for a cup of hot water, you walked past a faucet to get to, and I had to look at the floor for a second. I had the Casio in my purse. I had no intention of taking it out. I carried it the way people carry a medal in a pocket. For no reason I could have defended out loud. Margot called me first. Direct examination took 11 minutes and was almost boring, which she told me afterward was the entire point. Then Curtis Vane stood up. His theory was clean, and I want to give him credit, because he was doing his job well. If I was a woman who did not understand financial documents, then my signature on the 2016 transfer was uninformed and forgivable. If I did understand them, I had signed with my eyes open, and every dollar had moved with my consent. He needed me to be capable, which meant, first, he needed to establish that I wasn't. "Mrs. Alderman, you left the workforce in 2012. I did. And in the years since, your husband handled the household finances. He did. Would it be fair to say you don't have a background in accounting?" "No," I said. "That wouldn't be fair." He paused. He had a folder with my employment history in it and had decided it was thin enough not to matter. "You were a bookkeeper," he said. "For 8 years, Kessler Building Supply, on Webster Street, second desk from the window, purchase orders, reconciliations, accounts payable." That was a long time ago. 12 years and 4 months. Ask me something. Margot told me later that this was the only moment in the entire trial where she was afraid of me. The check for the Wyoming Street roof was number 4471, drawn on the joint account on March the 22nd, 2019, in the amount of $41,216.80. It was repaid on the 12th of September, 2019 by wire, from an account ending in 3308. The room did a thing that rooms do. "How do you know that?" he said. It did not come out as a question. "Because I found it myself, at 2:30 in the morning, before your expert did and before ours did, on a machine I bought in 2006. Curtis Vane looked at his folder. Then he asked the only question he had left, and I have never been sure whether it was strategy or whether he wanted to know. "Then why," he said, "didn't you read anything for 16 years? I had not prepared an answer. I want to say that. "My husband used to hand me a pen," I said, "and tell me I didn't need to look at that, because he already had." I heard that sentence about 100 times. I believed him every time. That's not a legal answer. No, it's the true one. It was my mistake, and I'm not asking anyone to take it off me. But it was a mistake. It was not ignorance. I'd like the record to show the difference." He said no further questions. I sat there for a second longer than I needed to. Nobody tells you that when being underestimated finally stops, you do not feel triumphant. You feel tired. You would like those years back, and they are not coming. Margot called Dean after lunch. She did not raise her voice once. She asked short questions with one door in each of them. Did you contact counsel regarding the Brandt Trust before the 16th of November? Yes. Do you know a woman named Deanna Voss? Yes. Did you forward privileged correspondence from Mr. Vane to your mother? Yes. Did you provide Ms. Ostrom with complete account statements? He waited a second too long. I gave her what was relevant. You gave her what was useful, Margot said. That isn't the same thing. Judge Prager wrote something down. It took him 4 seconds, and he did not look up. In 11 months of this, it was the loudest sound in the room. Dean looked at me from the stand, not with anger, not even with regret, exactly, with the expression of a man rechecking his arithmetic and finding it wrong. Margot took 10 minutes to explain what the trust actually was, and Judge Prager listened to all 10 without interrupting. It is a spendthrift trust. I am the lifetime beneficiary. I am also the trustee, which means I administer it for Theo and Josie, and for their children if there are any. Under terms, my grandfather wrote in 2011 and never once mentioned to me. My client does not own it, Your Honor, Margot said. She keeps it. I watched Dean's face when she said that. I had spent 11 months preparing to reach $28.7 million. What he had not prepared for was the sentence underneath it, that a man who knew us both for 16 years had looked at the two of us and decided which one he would trust to hold something. It was not me he thought had earned money. It was me he thought would not spend it. Then Margot turned to a section of the trust I had never read, because I had never read the whole thing. Nobody reads the whole thing. There was a gift in it for Dean, $400,000, and the cabin at Hocking Hills, 2 bedrooms, a wood stove, 40 minutes off Route 33. We spent 4 days there in October 2007, 3 weeks after the wedding, because it was what we could afford. And Dean fixed the pump with a borrowed wrench and was proud of himself for a year. My grandfather had left it to him, not to us, to him. And the paragraph after it read that the gift lapsed in full if the recipient initiated or joined any action seeking to reach value or divide the assets of the trust. The complaint was file-stamped at 8:04 on a Monday morning in January. Page 1 requested an allocation of trust-derived property. He lapsed it at 8:04 in the morning. He was served coffee at his desk by 9. He did not know it was there. Nobody had told him, because telling him would have been the warning, and the warning would have made the clause worthless. That is the whole architecture. It only works on a man who does not know he is being measured. I did not know either. I want that on the record too, because there is a version of me in this story who is quietly holding a card, and she does not exist. I learned about the cabin at the same second he did, in a courtroom, from my own attorney's mouth. That is the only reason I can tell you this part without shame. I have wondered since whether I would have told him, if I had known. I would like to say yes. I am 43 years old, and I have stopped answering questions like that too quickly. Hun put both hands flat on the table. He was not looking at the judge, or at Margot, or at me. He was looking at a point on the wood about 8 inches in front of him. And I knew that he had gone back to that October and was standing in a 2-bedroom cabin in 2007 with a borrowed wrench. Then his mother stood up. He didn't know, Loretta said, to the room. None of you told him. The bailiff was already moving. Judge Prager said her name once. She said it again, louder, And then she was being walked toward the door with her purse against her chest. She did not resist. It was not dramatic. It was a 71-year-old woman being asked to leave. I found her in the hallway afterward, on the bench by the elevators. She said 3 sentences to me. I have never forgotten the order of them. I was 42. Ray left me nothing on paper. I lost the house on Ackerman in 11 months. I did not answer her. That was not restraint or grace. I did not have anything. And I stood there long enough for both of us to understand that. And then I went back inside. The ruling took less time than the coffee line. The $3.2 million claim was denied in its entirety. The court found the separate property fully traceable and the repayment record complete. Judge Prager noted, on the record, that incomplete financial records had been furnished to a retained valuation expert, and that the characterization of the marital contribution in the original filing was not supported by documents in the parties' own possession. He ordered Dean to pay my attorney's fees. Then he closed the folder. It took him 9 seconds. It had taken my grandfather 4 years. Here is what happened afterward. I am going to tell it plainly, because I have decided that the plainest version is the most honest one. Dean sold the condo in the Oregon district 9 weeks later. He rents a 2-bedroom on the west side now, near the river, with a parking space he pays extra for. His contract as regional director was not renewed in August. Nobody fired him. There was no meeting, no escort, none of the things people imagine. Meridian simply did not offer another term. And a man in his position understands what that means without being told. I think that is the cruelest way a company can do it. In September, Theo turned 15 and asked to go down to 1 weekend a month instead of 2. I did not suggest it. I asked him twice whether he was sure, and both times he said he was busy. He is not busy. He is a sophomore with 2 clubs and no job. He is doing the thing his father taught him, which is to say a reasonable sentence out loud instead of the true one. And the cabin at Hawking Hills was retitled into the Education Trust for Theo and Josie in the spring. Dean has never seen it. He fixed the pump of a house he was going to be given and never knew it. And now his children own it. And one of them will probably learn to drive on that road. I went to see Loretta once, in June, without calling first. She made coffee. Her hands were not steady with the pot, and I did not offer to help, because offering would have been a kindness, and I had not decided whether I was going to be kind. She said she had only ever been frightened for her son. She said she knew what it was to be a woman standing in a hallway with no paperwork. I was afraid it would happen to Dean, she said. I put my cup down. You were afraid of what happened to you, I said, so you made sure it happened to your son's wife instead. You didn't stop it. Loretta, you moved it 1 seat over. She did not argue. I think she had already worked that out, on the bench by the elevators, and had been waiting 11 weeks for somebody to say it in a kitchen. I thanked her for the coffee. I put my cup in her sink. I have not been back. Dean came to the door on a Saturday in October. The kids were still upstairs. He stood on the porch with his hands in his coat pockets, and he said, I didn't know about the cabin. I know. I waited. There was more that was supposed to happen there, and both of us could feel the shape of it. And I let the shape stay empty. Then I turned around and called Josie down. I am not proud of that. I am also not sorry. There is a kind of silence you owe somebody, and a kind you are allowed to keep. And after 16 years, I have finally learned to tell them apart. I get up at 6 now. That is not a discipline. That is just what happens after a year of waking at 4. The house is quiet then. The refrigerator runs. A car goes by on Ridgewood. The Casio sits on the right side of the kitchen table. plugged in, and I have stopped putting it away. And the tape roll gets changed about every 5 weeks. Last Tuesday, Josie came down early in her socks. "What are you doing?" "Reading." "Reading what?" "Everything," I said. Behind me, on the hook by the back door, is a brown wool coat with the shoulder seam taken in twice by a man who did not believe in buying a second one, and once more, last winter, by a tailor on Wayne Avenue, so that it fits a 15-year-old. My grandfather left me $28.7 million. That is not what I inherited. What I inherited was one line, written on an index card 4 years before he died. Pay it square, and don't give anyone a reason. If somebody in your life ever decided what you were worth before they asked you, I would like to hear about it. Put it in the comments. Somebody reading them tonight is going to need to know they are not the only one this happened to. And if you want more stories about quiet people who kept the receipts, subscribe. There is another one next week.